Hey everybody, Paul Yokubaitis from Cary Estate Planning back again with another video as part of our estate administration series. And today I wanted to talk about qualifying as the executor of an estate. So if the decedent or the person who passed away had a will and the will named an executor who is still living, the named executor is generally going to submit the application for probate and letters testamentary to the clerk of court in the county where the deceased resided. That's where their domicile was. And that's essentially setting forth that they are the named fiduciary in the will or the last will and testament, and that they are requesting to essentially be qualified to serve as a personal representative of the estate. And so that generally requires, obviously, the completion and submission of the pleading itself, but also the original will of the deceased, setting out that they are indeed the executor named. And then on the application, there's also going to be some details as to the personal information of the deceased, the information of the purported executor, the information of the purported beneficiaries as set forth in the will, and then a preliminary inventory of the deceased individual's estate assets. And those are generally going to be personal property, and then some assets that are generally not probate assets, but could be included in probate if there are creditor claims that exceed the amount of the estate, which could be transfer on death, designated assets, real estate, and so forth. So that's the initial pleading that's submitted along with the, oath of the fiduciary, and then any sort of ancillary documents like death certificates and potentially a appointment of resident process agent if the executor is out of state. Next, we'll look at qualifying as administrator. This is Paul from Cary Estate Planning.